Okay. Hi, everybody. Okay. My name is Gennaro Dutero. On behalf of ISNAF, I'd like to present our next speaker. He's a local area attorney. His name is Gerald Klein. Just to give you a brief intro of Gerald, he's a certified family law specialist, certified by the State Bar of California. His practice is limited to all aspects of family law, especially emphasizing custody and mediation, and he's been in practice since 1976. Mr. Klein has served as a part-time juvenile court referee and as a volunteer temporary judge. He's currently an assistant professor of law at Irvine University College of Law in Cerritos, California, and has taught divorce mediation theory and practice through the University of California Irvine Extension Program. He has written numerous articles and spoken extensively on family law issues, including presentations at the American College of Forensic Psychology and as a presenter at a mandatory continuing education program for child custody evaluators. Mr. Klein has been widely recognized by both state and local professional organizations. Prominent awards include the Orange County Bar Association Family Law Section George Bailey Award, 2008, the California Association of Marriage and Family Therapists Honorary Distinguished Member Award in the year 2000, the Orange County Bar Association Liberty Bell Award, 1988, and the State Bar of California President's Pro Bono Service Award, District 8, 1985. He is the founder and executive director of Kids First, a nonprofit 8-week interactive educational program for families in divorce attended by both parents and their children. Gerald is also past president of the Family Assessment, Counseling, and Education Services. He's a past president of also the Children of or Parent Emergency Services, and which is a shelter for abused children. And he is a past president of the West Orange County Bar Association. So I'd like you all to welcome Gerald Klein. Thank you.
Thank you. If I didn't know better, all those nice things mean I know something. And it's amazing how much we do not know. I'm wearing the Kids First hat because I want to tell you about it for a moment. There are brochures about our program in the back. We will attack each person, the parent, the other parent, and the kid. A beneficial result at Kids First is not dependent on either party getting fixed. It works on each individual to improve the situation for them and the child. Our next program starts March 16th, and you can find us at kidsfirstoc.org. I've heard some of Catherine's presentation, and I wasn't here for earlier ones, but I'm assuming we're not getting a lot of good news here today, but we are getting information. Sarah Dowdna, who is our clinical director at Kids First, is an MFT. She's in the audience, and she has done a lot of work with parents going through parental alienation issues. Feel free to speak with her at any time. Okay. I'm working on someone else's computer, so I have to figure out wrong button. First of all, I'm going to try to give you information from the trenches. I've done litigation, I've done mediation, I've done consultations as an attorney in parental alienation. It's a complicated area. It's not an area where there are a lot of successes, unfortunately. First of all, there's no such thing as parental alienation syndrome. It has not yet been recognized by the mental health community, though the DSM-5, which is about to come out or has come out, was playing around with the question of should we include parental alienation syndrome. I don't believe it made it in, though I don't have a final word on that. In some ways, it would have been detrimental, I think, to us who work with parental alienation, because if the court has a list of things that the DSM-5 would say is parental alienation, and you're missing an element, or you don't fall into the elements, then the court may find there is no alienation. And we all know that there is alienation, whether it's a syndrome, whether it follows all 20 or all 50, or just 2 of the elements. We know that an alienating parent, intentionally or otherwise alienating parent, will do the job. You do have to look at the dynamics of alienation, and that's what we're going to do here today. There's no commonly, this is therapist language. Basically, it says these are the reasons why you can't call it a syndrome, because you can't replicate the elements. But alienation exists. If you have a specialist that's going to go up and testify in front of the court and tell the court there is parental alienation syndrome, the other attorney is going to destroy that expert because they can't prove that there's such a thing as a syndrome. Stay away from syndrome and talk about the behaviors that are leading to the alienation of the child. In California, as of a few years ago, I've researched all of the appellate court cases. These are the cases that come into play after there's a trial court. And as the slide says, 3 of the appellate courts talked about parental alienation syndrome, 1 talked about parental alienation, and 2 talked about just simply alienation. In reading the cases, what it says is, if the trial court finds that there has been alienation, whatever the label, if they find that the child has been alienated, they will treat that as being a valid finding, and the appellate court will not interfere with the result at the trial court merely because of the language being used. The appellate courts give great deference to the factual findings of the trial court. Custody. We're in the state of California. How many have heard we're a no-fault state, right? Well, we're still a fault state, the last bastion of fault being child custody. It is still where the other parent can get up and testify under oath that parent A is a lousy parent, beats, abuses, molests, whatever they want to say, and I mean whatever they want to say, and they can get away with it because it's in the best interest of the child is the rule, not the best interest of the parent. With regard to Catherine's statement, to some extent what she's saying is everybody that gets involved with receiving allegations of abuse, molestation, that sort of thing, they all want to err on the side of the safety of the child. And the alienator goes out of their way to make sure that the courts will hear what is necessary to get them to err. And here's the other thing, kids first. It is the kids, not the parents. We're going to get to a slide that says the best interest of the children is the rule at the courthouse. It is not the best interest of the parent. And a lot of parents don't get it, and they shoot themselves in the foot for exactly that reason. California family law courts, as in most states, are what we call courts of equity. You ever notice there's no jury in family court? No 12 people in a box trying to determine whether you should have custody or whether you should get divorced or not. That's because there is a lot of equity balancing in the courthouse. The judges have tremendous discretion in a court of equity. And in custody cases, they have an even greater degree of discretion. And that discretion is both good and bad. I'm not going to go through to the... How many here have actually been through the court system? All right, I'm going to skip some of the generalities. Dr. Gardner was, of course, the gentleman, psychiatrist back in the 60s who self-published a book and first brought to the attention of the world parental alienation as a concept. It is subtle, we all know that. There are wild cards, and I'm going to skip those 3 items and go on to the next one. There are warning signs, and it's a disease. And like as with any disease, you have to identify and you have to treat early. And that's the problem at the courthouse. The judges are jaded. They see what could be alienation in almost every custody case. And getting the courts to distinguish between, quote, real alienation in progress and a passing time that is going, well, let me rephrase that, to distinguish between real alienation and something that's going to last momentarily is very difficult. And the courts, unfortunately, the reality is that they don't recognize alienation until it is either too late or almost too late. Once you get into, Gardner, as you know, identified mild, moderate, and severe. Once you get into severe alienation, it is extremely difficult to reverse. You know that. The behavior is so common, it is just ignored by the courts. Oh, it'll go away. The best interest of the child. You know that there are only 4 or 5 statutes in the Family Code in the state of California that actually define elements that a court needs to consider when ruling on custody. And that gives more credibility to my earlier statement that judges have a tremendous amount of discretion because there's little statutory guidance. The first is the best interest of the child. Isn't that nice? What's the best interest of the child? Well, it's the best interest of the child as it goes to the health, safety, and welfare in the child. There's another statute that says frequent and continuing contact with both parents is an important element to be considered by the court. Another one is the parent most willing to share is given primary consideration. And that statute, the parent most willing to share, is what is the target of negation by the alienating parent. Well, I would be willing to share, except he or she is beating, molesting, sleeping with, whatever. And we get back to err on the side of the child. Proving a negative is very difficult. One of the most frustrating things for me as an attorney, and I have some people I know in this room today who are going through it, the alienating parent writes a paragraph. And in that paragraph, there are 27 words. One is true. One is obviously true. And the truth, the obvious truth of that one word or one phrase throws an umbrella of legitimacy over everything else in the paragraph that may well be a lie, a distortion, and it's almost impossible to go through a 5 or a 10-page declaration, a word at a time, and to try to undo. Now, I sat as a volunteer temporary judge periodically, maybe once a month, once every couple months, and I did that for a number of years up in LA County in family law. And I had a very interesting experience that I shared with a couple of judges that I knew. There was a custody case, and I was in chambers, and when you're in your court chambers as a judge, and you're wearing your robe, the attorneys come in, they want to talk to you, they want to get your impression. And when you wear that robe, you are bestowed with this tremendous amount of knowledge. You just know it all. And the 2 attorneys come in. It was a male and a female, and I happened to know the male. I didn't know the female. And I'm sitting there listening to them as they're telling me their clients' positions. And I had to kind of keep a straight face, because inside, I was kind of laughing hysterically. I'll tell you what I heard. I heard, nyan, 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 whine, whine, whine. He did this, she did that, whine. Nothing that I could use to actually evaluate the case. And as the fantastic judge that I was, I just sat there quietly. I let them finish, and then I asked a couple questions that got me where I needed to go. But I mentioned that to other judges. They said, yeah, I know. They just, yeah. They don't get to it. They try to tell their client's story, repeat it from their client's mouth, rather than evaluating it and interpreting it in a way that is discernible and understood and meaningful and relevant to a court. And it is not the best interest of the parent. I should be able to see my child. It's in the Constitution. You know it ain't, okay? It's the children that have the right to see the parents, and they have the right to be safe and healthy, and their welfare needs to be taken care of. And these kinds of cases, it's an interesting thing. What happens if you have an unhappy parent? The law doesn't provide for an unhappy parent, but if you have a parent who is unhappy with the custody arrangement, that custody arrangement is going to fail. That is why we who do mediation, we who negotiate, we say that if you reach an agreement, there is a much higher proportion of the cases where the parties are going to honor that agreement because they were part of putting it together. I had a parental alienation case, married 4 years, went on for 12 years. As soon as the youngest child hit 18, the case ended. During that time, the court ruled against the alienating parent at every court hearing. That was 2 or 3 or 4 court hearings a year, plus 1 or 2 appeals by that person a year. As long as the court kept jamming down that person's throat, the court's interpretation, it wasn't working. Now, I'm going to bring up another side of that, and I don't want to offend anybody here, but most alienation cases, the alienating parent has a problem. Usually a DSM-4 problem, either a mood disorder, bipolar, or severe depression, or they have an Axis 2 personality disorder, borderline. You talk to therapists. Some of my best friends are borderlines, but you talk to therapists about borderlines, and they'll say, I don't want a borderline in my practice. Now, borderlines, you have the histrionic personality, obsessive compulsive, the narcissist, and you have mixtures of these kinds of things. And this is the 5% of the cases that will never settle. They will never, ever give it up. And there you have your high conflict cases. There are some rational and irrational motivations. The rational may be, I really think that dad or mom is doing something bad to the child. If that's the case, what you do is, let's talk about the first thing you don't do. The first thing you don't do is say that the child should never see the other parent. As a parent, if your child is having a problem, you go to the other parent, you say, this is the problem the child is having. We as parents need to address this. We should all be in counseling. Child should be in counseling. We should look at medication, whatever. This is what real parents do. Alienating parents don't do that. It becomes part of the plot, part of the surreptitious gathering of information so that you can ambush the other side in a way that they will never be able to recover from. Domestic violence. Anybody that has a domestic violence issue in the state of California knows that 3044 of the Family Code says if you've committed domestic violence within the last 5 years, you can't have custody of your child. So what's the first thing that people do? They accuse the other parent of domestic violence. Is it easy to do? Well, the forms have been designed so that they can be handwritten easily by laypersons. There is no filing fee. You want to file a divorce or paternity action? It's $435 filing fee. You want to go in on a request for orders, you can add another $65 or more to that. You want to file a domestic violence action? It's free. You can handwrite the papers. You can go to any courthouse and they will help you fill them out. They will help you convert your story into buzzwords that will bring the court to say, my God, I've got to protect these kids. I have to err on the side of protecting the kids. The domestic violence action has been expanded. You can get custody. You can get a move-out order from the house. You can get child support. You can get spousal support. You can get the other person to pay bills. You can get the other person to pay for counseling. It is a powerful tool, a very powerful tool. Back in the 70s and 80s, it was child molestation was the big thing. Today, domestic violence is big. The child abuse advantage is still there. The 12-year case I had, the woman went in ex parte. You've got to prevent this father, in this case. Sorry, I let the gender slip. One of the worst cases I've had, so you'll know, is a father who was the alienating parent. But in this particular case, the mother goes in ex parte, has a declaration, says, I took the kids to a counselor, and the counselor interviewed the kids and said the kids were being molested and abused and this and that and that and this, all by dad. I got a hold of the counselor. Counselor did a declaration that said the mother came in and said the kids were saying A, B, C, and D. The counselor didn't believe it, did not file a mandatory child abuse report. From that day on, the mother had monitored visitation. You know, there are a lot of relationships that a parent can have with a child that is short of being punitive, short of being retaliatory, short of being intended to cut out the other parent. I mean, children do, at different developmental stages in their life, they do relate differently to different parents, depending on the developmental stage, depending on their sex. You know, if a father and son are both, they look alike, they're both very interested in sports, I mean, you create a relationship that may be a little deeper than it is with the other parent. Young women, pubescent girls, they may relate better with the mother at that particular time because they can get more from the mother. And I will tell fathers that you have got to learn how to be the father you can be with the child that you have. It's not like when they were 4 or 5 or 7, you come over and watch television together or played video games. It's a different story. These children have their own life, and they want to have that life, they want to exercise that life, and you need to give them that latitude. For fathers, you can make your home base for your daughter, the same as the mother makes her home base for the daughter. The daughter can go on dates, get dressed up, do things. They can have friends over your house just as well as any other house. You may have more difficulty helping them put on their makeup, but maybe that's a class you want to take. I don't know. If you look at this chart, you can have a positive relationship with both parents, an affinity maybe with one for one reason, and that will shift based over time. You may have an alliance, and it could be a good thing, it could be a negative thing. And then you have estrangement, and there could be a realistic estrangement. I'll wait later to bring up something. And then you have the pathological problem of alienation. You have no preference, you have affinity, you have alignment, and then you have alienation. Gardner talked about those 3 levels. If you have intentional parental alienation, it is a conscious and detrimental effort on the part of the other parent to alienate the child from you. You could have active alienation, which is somewhat unconscious. Picture this kind of silly story. Child comes to visit dad. Child is a little upset. And dad says, gee, honey, what's wrong? He said, well, you know, mommy did this mommy did this, mommy did that. And the father, who is now a visiting father, if you want to use that term, just can't help it, but just gets a little smile. You know, you're talking to me, and you're a little angry with mom. And, well, I'll tell you what, honey, let's go get some ice cream. Child wants dad to be happy to see her or him. The child sees the smile. The child likes ice cream. Next time dad has a chance, he may be a little more overt in his subtly reinforcing what may be negative against the other parent, against the mother. The treatment is what needs to be looked at. The treatment is different based on whether you have an intentional or merely an active. If you have a severe intentional parental alienating parent, the best that you can do is to try to contain that parent. You're not going to fix them because they probably fall into the 5% of those whose pictures appear in the DSM. Best you can do is contain them. Your effort has got to be on yourself and on the child. And the child is most malleable up to a certain point. This is a triangle that I've worked out. As you see on the news, it's exclusive. You will see it nowhere else. This is what really is going on, and I'll give you a minute of background. I spoke at a conference, and the day before I spoke, there was a renowned author on parental alienation that spoke, and at the end of his talk, he said, and you know, there are some cases where the alienating parent just tries unbelievably hard to alienate the child, and they don't get alienated. The next day, he was in my audience, and I addressed that, and I addressed him directly. I said, the reason is the wild card is the susceptibility of the child. The susceptibility of the child. This triangle juxtapositions the powers of each of these three people. It is the power and the intensity and the persistence of the alienating parent together with the weaknesses of the parent to be alienated. What are alienated parents good at? Finding weaknesses in the other parent and exploiting them and exaggerating them. And finding where the child's fears and concerns can be exploited. These are the powers of the alienated parent. And then you of the alienating parent. Then you have the alienated parent. I didn't do anything wrong. It's exaggerated. It's a lie. I shouldn't have to do anything. The other person is bad. It's all the other person. I shouldn't have to do anything. If you talk to Sarah Dowden, who has done these things, who I mentioned earlier, you talk to me, my experience is the alienated parent feeds into the allegations of the alienating parent. They righteously believe I shouldn't have to do anything. I didn't do this. Well, maybe so. But if you want to have your child back, and you want to have a relationship with your child, and as far as I'm concerned, if you have a severely alienated child, and you have any relationship at all with that child, you're a winner, because those cases are difficult. You need to do, and what happens is, you react to the alienating parent in front of the child, just the way the alienating parent tells the child, you're going to react. And it just reinforces all those negative things that have been said about you if you're the alienated parent. You have got to take responsibility for your part. If you want to be self-righteous, and forgive me for this, I usually don't reveal this, but I was talking to someone else who has an alienated child, and my comment was, we the lepers. I went through it, so I understand it. I lost my child, but I saved my life. And sometimes you have to go there. The alienation process, again, is the strength and persistence of the alienating parent, the relationship weakness with the alienating parent, with the alienated parent, and the dysfunction or pathology. There is a pathology with that child, and that has to be addressed. I'm going to skip over that. This is one of the big problems you have in the courthouse. What time am I done? Somebody tell me. Nobody knows. I guess I get the whole afternoon. The best interest of the child. You go to the judge. You convince the judge that the child has been alienated by the other parent intentionally. The child hates the alienated parent. The alienating parent has been beatified, and the alienated parent has been demonized. The alienated parent is all bad, devil. The other parent can do no wrong, is perfect. Okay? So you tell the judge your story. You have a 1-day trial or a 10-day trial. You spend $25 or $30 or $50,000 with attorneys and therapists. And the judge says, you're absolutely right. This child has been alienated. Now, in the best interest of the child, what do? Do I tear this child, kicking and screaming, from the parent that they love and idolize, and make them go with the other parent who they hate and demonize? I had a long trial. I got everything I wanted representing the alienated parent. The 3 children were ordered to go with my client, who happened to be the mother. The children were a couple teenagers and a 9-year-old boy, 2 teenage girls, 9-year-old boy. I got great orders. Dad, if they ran away, Dad had to bring them back. If they called Dad, he had to say, hi, how are you, goodbye. He wasn't allowed to see Dad for 6 months. It was great. We won. This family, the kids went to live with my client, Mom. They tore Mom's house apart. They hit Mom. They kicked Grandma. They ran away. They wouldn't eat. It was a disaster. But we won. How do you fight that? I recommended to the children's attorney that the mother and the children meet with that attorney. They reached an agreement where the mother would have absolute specific visitation. And as long as that visitation was kept, the court order for Mom to have exclusive custody would not be enforced. To the best of my knowledge, that worked. That was the best I could do. But it wasn't working the other way. Gardner had recommended in his books that the child be put into a psychiatric institute. Best interest of the child, let's take the kid from his family and put him or her in a psychiatric institute. Best interest of the child? That's nuts. This is art. It's a little bit of science. It's very, very little science and very little law. It's discretion. What happened? No scientific formula. Art, science. Court of equity. I told you that. I'm going to pass that. There is always alienation in almost every case. As I said, passing at the beginning, it is getting the court to recognize that what is going on now is alienation, and if it's not stopped, it will become irreversible. But because the court sees these kinds of behaviors in most of the cases that come before it, it is very difficult to get them to act. Judges have trainings. I don't think any of the judges, as good as they might be in Orange County that I'm aware of, have had specific training in parental alienation. And there are different opinions on parental alienation. There are some people say, from the scientific standpoint, it doesn't exist. We know differently. Morsels of truth, giving credibility to half-truths, distortions, and lies. Creating reports with third parties, calling the cops, filing police reports, calling child support services. The 12-year case, the woman probably called child protective services a half a dozen times, cops a half a dozen times. Poison is set. I had a 10-day trial on parental alienation. There were 2 children. And the older child was totally alienated from my client, who was the father in that case. And the younger child was not. So the judge played Solomon, gave my client custody of the younger child, and mother custody of the older child. And I hear from the father periodically. That was the 4-year marriage, 12-year divorce. I spoke with the father. He called me about 3 months ago. He has a relationship with both children and with the mother. And we talked about that. And he happened to have been an attorney, by the way. He had profound a profound statement for me to embrace, to pass on. He said, I always treated the mother with respect. The children never saw me disrespect this woman who was a borderline, who was out of her gourd, who would say and do anything, who never made a statement that was true in her life. On cross-examination and trial, I had her so shaken because of every lie that was exposed, which is a rare occasion. When you have to win your case by cross-examining the other party, you're going to lose, because the other party is going to be there to say and do anything. You don't win by cross-examining the other party. But I had this woman so shaken that I actually had her admit that the truth was a lie just to get out of the situation. I mean it, I swear to God. Okay? I call it the virus. Have you had a situation where the parent who is the alienating parent goes up and testifies in front of them, but Judge, I told Janie they have to go visit with mother or father. I told her get in the car. Well, she's 15, he's 13. I can't, he weighs 180 pounds. I can't force him to go. It's perfect, okay? You have alienated the child. The child has the virus. Now you can sit back and be wonderful and beautiful. For those who do this work, you have to identify family of origin issues. It's amazing how many families, after you talk to them about their intact family history, will reveal that alienation was taking place while the parents were still living together. Therapists, they love me, hate me. You go to therapists, the therapist says, tell me how you feel, lay down on the sofa. The truth will come out in 4 or 6 or 9 months or a year. We'll get there. That's not how you treat alienation cases. First of all, you have to understand alienation, and you need to interrogate the clients. You need to make them support and explain what it is they're saying. You just cannot accept it. This is a 45-minute honing down from a 3-hour program, honed down from 5 hours. I'm not going to get to cover the stuff that I want to cover. I apologize for that. Look at some of the children who are alienated will have no remorse, no guilt. Their history would change. Mom and I never had any fun together. We never did anything together. And I remember when Dad beat me when I was 3. History changes. A couple of kids that Sarah happened to work with, we never did anything with Mom. Mom never did anything. Sarah had the mother bring in hundreds of pictures. Showed the kids pictures of them in the park, playing, laughing, doing things. Is that me? Is that Mom? Did that really happen? It also tells the kids, my God, the other parent's been lying to me. The parent I idolize and trust has been lying to me. Do you know how hard it is to get a kid to be able to accept that? And a lot of kids are given a choice. You can either have a mother or a father. You can't have both. You can either have me or you cannot have. If you have the other person, you can't have me. I will not be in your life. That's pretty powerful stuff. If you think there's any slides here that has detailed information you would like, my email address is kindlaw, KINDLAW, @AOL.com. If you email me, I will send you a copy of this PowerPoint, because I'm not going to get through all of this. The alienator will not only isolate the child from you, but will isolate you from everybody else, from the other family members. Had a case where grandma calls. Child tells grandma, don't ever call here again. What did grandma do? The alienated parent, if it's not intentional and they're not getting too much joy out of having your child be their child alone, may respond to some intense therapy by someone who actually knows what they're doing. But you need, at worst, to contain that parent. Let me see if there's anything else. I am told that I am done. I don't know whether somebody comes up right after me. Can I answer some questions for a couple of minutes? Okay. I'm sorry, someone asked something? You have to get a judge. Generally speaking, the best interest of the child, according to all the therapists, according to the experts, is to have an open parenting arrangement. That is the best interest of the child. In alienation, it is exactly the opposite. You have to have the most specific, detailed. When you pick up the child, you open up the car door with your right hand, okay? And the best thing that you can do in your order is to never be picking up the child or returning the child to the alienated parent. It has to be at some neutral place with a neutral person that's not the alienated parent's best friend, not their mother or father, not their brother. It has to be some place where the child does not feel obligated to hate you. When the child first comes to you, it takes an hour to warm up. When they're about ready to get back home, they start getting cold again so that they can go to the other parent and say, I had a horrible time. They'll be on the phone texting. Cell phones. Cell phone is the weapon of the alienating parent. Try to take a cell phone away from a teenager. And by the way, the people that are susceptible, emotionally susceptible to be alienated, are 9 to 15-year-olds. The pubescent, prepubescent are the absolute most susceptible. You have a 5-year-old who repeats, I hate daddy, I hate mommy. That's not visceral. That's not coming from the gut. They're just repeating. But if that behavior is allowed to continue, it can go into real alienation. The strongest weapon you have is you. If you do what you need to do, if the alienating parent is 99% wrong and you're 1% wrong, you need to address the 1%. And you need to treat the other parent with respect, never disrespect in front of the child. And avoid, this gentleman told me, the case I told you about, avoid self-defeating behaviors. Wouldn't you love it to say, bitch, or son of a bitch, you doing this? That doesn't help you. Your goal is to have a relationship with your child and have it cost less than $100,000 and keep them from moving to Texas with your kid. I'll be available. I'll be here as long as I can, and I'll be available to answer questions. Yes, sir?
Looking to the next generation, I'm wondering, are you aware of cases, what the likelihood would be of a judge issuing an order or finding along the lines of saying, here's a pattern that we observed, this finding could then be issued to the next generation's court or DCFS or police or what have you?
Well, here's what you have. These agencies are not going to be working with one another per se. In California, you're supposed to have judges assigned for all purposes. So you may have the same judge for a long time. But even so, you have a court that makes findings and it's in that court file. Your attorney, or if you're representing yourself, which is like shooting yourself in the foot, taking out your own appendix with a rusty penknife, okay? You have a court file with findings, and you can bring that to the attention. But you know, you go, as Catherine McMillan said, you go to the police and the mother or the father who's alienating. They're very bright. They're convincing. Borderline to some of the brightest people in the world. They will convince the people. You go to the cops and say, disregard the allegations that I'm trying to murder my child because a court 2 years ago found alienation. Cops aren't going to be interested in that. They're going to worry about the murder of the child today. I apologize for not having more time. I hope I hit some of the highlights. I will be available to talk. And I do truly wish you all the best.
Hello, I'm Catherine Sandoval, and I'm here to introduce our next guest, Bill Kable, Bill Kable, and his wife, Catherine Barrett, from Sydney, Australia. He is a targeted parent of 2 adult children. He went through family court for 10 years, along with his very supportive wife, Karen, who has been there by his side. And they have a radio show in Australia called Dads and Families. And it's been going on for about 3 years. And he has contacted and has done interviews with people, judges, lawyers from all over the world that have to do with parental alienation. And his most recent contact was a judge from Brazil when they had some new laws passed that he can tell you about. It's very interesting. He is from Australia, as are his many ancestors, and I have learned that Australians are very proud of their convict lineage and are glad to tell you about it. They feel that makes them part of the history of Australia, as we do when we say, my grandparents or my ancestors came here on the Mayflower. So he's a very interesting person, as is his wife. I've had the pleasure of hosting them. They will be in town tomorrow in case anyone wants to talk to them, and he has a great deal of insight to give us today. Thank you very much.
Thank you very much, Catherine. After that sort of introduction, yes, I'm from convict stock. Some people, I'm also a lawyer, and some people say I'm still in the same line of business. But to all those distinguished guests and concerned parents, I want to say good day, and thank you, ISNAF, for inviting me today. So far from home for me, and it's been emphasised by listening to the speakers today, I always find it surprising that parental alienation manifests itself in almost identical form all over the world. For this reason, I hope you'll find it interesting to hear about some of our experiences down under and how we are coping, and to compare it with what is happening over here. I want to describe to you the formation of the family court in Australia, the intention at the time compared with the reality. Then I want to focus on the treatment of parental alienation, one aspect of family law which is the reason why we're all here today. And I'll illustrate this with my own case and look at what is being done to fight this menace with a glimpse of what the future may hold if the lesson from another case I will mention is heeded. The Australian Family Court was heralded as a progressive reform of the 1970s. Now it is perhaps the most hated institution in Australia. The Family Law Act of 1975 removed fault as a ground of divorce and replaced it with a single ground, namely irretrievable breakdown. And this is proven by 1 year's separation. It was to be a caring court or a helping court. Marriages would be dissolved without trauma, and although there would still be property issues, maintenance and custody of children to be sorted out, these were going to be settled in a simple, flexible and inexpensive way. Litigation would be discouraged, and the court would be staffed by social workers and counsellors as well as judges. However, with apologies to some of the lawyers here today, with lawyers in charge, proceedings quickly became complex, rule-bound and expensive. And although the caring court looked more and more like an ordinary court, it differed significantly in one respect. The court hesitated to act like an ordinary court when its orders were disobeyed. In a case G&G from 1981, a father had abducted his son from his mother and lived with him for 4 years before they were discovered. The man was sent to jail for 2.5 years for defying the court's orders, his offence being that he had isolated his son from his mother. But the court had this dilemma. Was it now going to damage the boy further by denying him his father, with whom he got on well? The judge decided that this was a contempt matter, and therefore the welfare of the child was not the paramount consideration, though it is a matter that must be considered. The reasoning was supported on appeal because of the effect on many other children. So this was a hard-headed pronouncement, and it occurred when the father did not have custody of the children and had taken matters into his own hands. When the court came to consider breaches of orders by custodial parents, who are in Australia usually mothers, it returned to being soft-headed. The typical case was where a mother contrived to deny a father access to his children, even though he had orders allowing access, usually weekends and half-school holidays. Now the court declared that the paramount interest of this particular child should prevail. So since the court decided it couldn't fine or imprison the mother without having some effect on the child, those options were abandoned. So the caring court re-emerged. Since access orders were defied with impunity, thousands of children were kept from their fathers. And this is going on. Mothers contrive to deny access to fathers by being away when the father calls, or claiming that the child is ill or doesn't want to go, or I think we've just heard about some of these situations. The allegations that the father is mistreating the child or relocating. And the mothers have really nothing more to fear than maybe a slap on the wrist, and they can very easily exclude the fathers from the children's lives. And similar situation as we've heard about here, the court is not in any manner responsible for enforcing its own orders. The aggrieved party has to commence the contravention application at that party's own cost, and if it's not proven or if there is a reasonable excuse for the breach, the aggrieved party may be liable for the other party's costs as well. If the custodial parent decides on access, why have a family court at all? It's not so much a caring court for the thousands of non-custodial parents who have wasted their spirits and resources in a futile attempt to get the court to enforce its own orders. So that's the family court. In 1999, the federal government established the Federal Magistrates Court in the hope that some family law cases may be resolved quickly and cheaply, which is what we thought the family court was supposed to do. But this didn't change the situation, where orders are a joke and judges and federal magistrates continue to produce them. If the orders were conscientiously framed to advance the best interests of the children, then you'd have to ask, well, by failing to enforce its orders, the court's been systematically damaging the children under its care. The approach of the family court can be summarised in this way. The court encounters a broken family, the husband and the wife have separated. Then it creates a second break between the parent and child. It reduces parents to the status merely of being candidates for involvement in their children's lives. It then reassembles the child and the parents in the way that it considers will best advance the interests of the child, but it does not enforce the orders. I think we've heard a number of mentions this morning of constantly referring to the best interests of the child, but to me this begs the question, which is, what is in the best interests of the child? That's the difficult question. There were some changes in the family law in Australia made by the Howard government in 2006. And these have been frequently misrepresented both in Australia and other countries. Sometimes Australia is held up as a model example for family law. The new legislation set out two primary matters for consideration by the court, these being called the pillars. The pillars are the right of the child to know both parents and the right to safety. In describing the right to know both parents, there was a rebuttable presumption to equal shared parental responsibility, and the court had to consider equal shared time, and if not equal time, then substantial and significant time. substantial and significant time was interpreted to mean not just every second weekend at half-school holidays. It meant midweek time so that the non-resident parent would be involved in day-to-day activities like homework and school lunches. It was to avoid an expression we even know in Australia, the Disneyland dad. Still, no rights were given to parents, and the court has a long and unfortunate history of dealing with matters that are to be considered, usually by going back to the old best interest of the child formulation. Nevertheless, this was interpreted in other places as introducing equal shared time. In Australia, the common understanding was that equal shared time had been introduced, and rather than the sky falling in, many settlements were arrived at giving fathers more significant time with their children based on this misunderstanding. That then led to action by a number of the women's active groups in Australia who were not pleased with this development, and they mounted campaigns and logging exercises based on the alleged risks of domestic violence by the father. Their aim was to amend the legislation despite the short period in which it had been in operation. And so it came to pass that based on the old misleading claims about domestic violence, the right to know both parents lost its priority, and a whole raft of domestic violence amendments were passed in 2012 to beat the men into submission. Not enough time has passed to see how these translate in the courtroom setting, but I want to give you just several examples of domestic violence that is now encompassed under the legislation. One of these is shouting at your partner or your children. Another is being cruel to the family pet. Perhaps the best or the worst of these is the denial of financial resources. In a situation where the father may be the only income earner in the family and he refuses to advance the money for a wife to, for instance, buy a new car, this could constitute domestic violence in Australia. And the test is subjective, meaning that the wife only has to feel that she's a victim and she's subject to domestic violence. So, how do you possibly argue against that? The family court judges, though they see plenty of evidence to the contrary, I would say are the last supporters of the view that Hamlet put to Horatio, "Frailty, thy name is woman." Now, parental alienation in Australia, can we have high expectations of the legal response in view of what we've heard of the history there? Australia also has no-fault divorce, and one of the faults of no-fault divorce is that it allows one partner to surprise the other with the declaration that the marriage is over without having to give any reasons or undertake any negotiations. In marriages where there are children, over 80% are initiated by one parent, and I agree with those that say, as a rule of thumb, that it is the parent, woman or man, who thinks they will control the children who breaks up the marriage. With the prospect of one parent controlling the children, the scene is set for parental alienation to flourish. I don't see parental alienation as being the province of one sex only. I'm aware of the Pamela Richardson case in Canada, and I know some other distressing cases in Australia and obviously here in the US. So it cannot be categorised as some sort of male gets square. In fact, by recognising that PA is not sex-specific, we are more likely to get some action. But the alienator in Australia is more likely to be the mother because of the greater opportunity of the custodial parent to alienate. Unfortunately, there have been no conferences like this on parental alienation in Australia. A Google search for Australian professional papers on parental alienation will lead to disappointment. There are some papers by Janet Johnson. I think one of her articles was referred to a little bit earlier. She doesn't support parental alienation. You may find one by social worker Paul Lodge, but the biggest development seems to be a change of name, so that parental alienation is now more likely to be called extreme alignment, where it is acknowledged at all. At a family law conference held in Tasmania at the end of 2012, when a federal magistrate had concluded his presentation generally decrying PA, a lawyer colleague of mine queried him about the instance of parental alienation. The response was, parental alienation? That's a bit passé, isn't it? So There is no reference in the legislation to parental alienation, and if proved in court, it generally will not lead to the court doing what has to be done, namely ordering the child to be removed from the alienator and spending time with the target to squeeze out what Dr. Richard Warshak describes as divorce poison. But even to get the word out in Australia is difficult because we have a section in the Family Law Act, section 121, which is worded such that any person who publishes in a newspaper or periodical publication by radio, broadcast, television, or other electronic means, or otherwise disseminates to the public or to a section of the public by any means any account of proceedings or part of proceedings that identifies a party to the proceedings or a person who is related, or the legalese here, but generally speaking, any reference to a particular court case will be a breach of the Act, and it is punishable upon conviction by imprisonment for a period not exceeding 1 year. Identify is defined as including the address or residence, physical description or style of dress, employment or occupation. However, this far from Australia, I feel free to speak openly, relying on the limited extraterritorial jurisdiction of the family court. A pioneer in the area of parental alienation is Dr. Richard Gardner, and from the work of Dr. Gardner and Dr. Warshak, we can identify symptoms of PA when a child rejects a parent for no good reason. It may be fortuitous for this conference, if not for me and my children, that I can give personal examples of the symptoms of PA being exhibited. And I'm sure many of you here, if not everyone here, will be able to identify with these situations. The parental alienation of my son started when he was about 11. It came as a shock to me when I started seeing the effect of PA. I guess the first surprise was when I was told by the mother, my then wife, that the marriage was over. And when you're still coming to terms with that, then you get hit with the life you've been leading, say for the previous 11 years in my case, was over. And my then 11-year-old son started on a campaign of hatred. Certainly with no gratitude for anything I'd done. I heard him telling my mother that because I didn't give them enough money, he couldn't eat breakfast. I'm sure that came from somewhere else. And despite a lot of, we actually did a lot of planning for activities that he might like. We went to the Sydney Olympic pool, but everything was a drag, and he was absolutely determined not to enjoy himself. And it's amazing if you have that sort of determination, you really don't enjoy yourself, you know, it sort of follows. If a photo was taken, he would always ensure that he looked miserable in the photos. He was abusive to me in language that I'd never heard before from anyone. I was amazing I don't know where he got it from. I took him away on some trips for some one-on-one time. Among other things, we went to the Blue Mountains out of Sydney for bushwalking. We went to a beach apartment for a holiday. We went on a skiing trip. And yet extraordinary allegations arose out of all these holidays, and they were documented in affidavits prepared by the mother and subsequently filed. In the Blue Mountains, my son and I shared a four-berth room at the Katoomba hostel of YHA Australia. YHA Australia is proud of the Katoomba hostel. It's one of the highest graded hostels in the world's largest backpacker accommodation network. In the room was another young man, but there was hardly any interaction. My son chose the bed he wanted from the remaining three, but it turned up in an affidavit that I was exposing him to a pervert. My activity during the skiing holiday was described as lying around in my underpants watching TV the whole time. I mean, I knew that wasn't true, but there wasn't even a TV in the cabin, so... After that, my son, who by now aged 12, simply refused to see me, and I wasn't prepared to force him physically to come. So he dropped out of my life about 11 years ago, except for when I'd see him in passing while arriving to collect my daughter at the mother's country property. The last time I saw him, he came running down to scream at me in front of his mother that he was not my son and that he wished I was dead. My daughter was... so that's my son. Now move on to my daughter. My daughter was only 4 at the time of separation, And so while there was a longer time for the parental alienation to take effect, initially it just seemed to bounce off her. At one memorable occasion when she was about 5, my daughter was sitting around colouring in, and she mentioned to my new partner, Catherine, who's here today, Mummy says you're a fuck. And then kept on colouring in, which we found was quite amazing. But we did, with that at that time, because it hadn't taken root, there were about 4 to 5 years of fun times with my daughter, even though the mother was always trying to limit my time with her and create difficulties. But I kept at it, and I took advantage of every opportunity to be with her. And we would praise her all the time. Catherine would say to her that if she ever had a daughter, she would want that child to be just like her. Then from about the age of 9 onwards, my daughter began to change until by the age of 11, there was really no hope left. All the symptoms were there. You can tick the boxes. There was a campaign of hatred with no gratitude for any contributions that had been made. When the mother moved, she relocated about 180 miles north of Sydney, but there was no recognition of the travelling that we had to do to see her, just on weekends. She scratched on the door of her bedroom in our rented house, "Catherine and Bill, I hate you." There was never any sign of affection. Even if I went to, say, put my arm around her, she'd pull away. And similarly with Catherine and other members of my family, everyone gets lumped together with parental alienation. When we went on holidays, when she was enjoying herself, she made a point of getting that same look on her face that my son had, the miserable look, were just sort of like, it was like flicking a switch. There was no guilt for treating the parent with malice and disregarding the parent's feelings. There was certainly never an apology for anything. I think the biggest worry for me was when she started running away from home, and once she went missing after school when I arrived to collect her. You understand that when an alienated child will treat you worse than she'd treat a complete stranger. Even perhaps more than that. I mean, if she saw an animal, she'd go out of her way to hug and kiss the animal in front of me, while refusing to, let me put my arm around her or anything. There were trivial explanations for the hatred. The usual comments were, "You treat me like a baby. You just don't listen to me. You don't care about what I think." I can't tell you how many times I heard that. By contrast, of course, the other parent is perfect. And I have a particular beef with, sorry Karen, a particular beef with some social workers in Australia anyway. My daughter was interviewed by a social worker for a court report, and she was asked if she could think of anything good about me or anything she had enjoyed doing in her whole life, and she said no. And yet, only the week before, we'd been on a holiday to Dubbo Zoo, where she'd ridden a bicycle around a plain zoo, and she'd been seeing rhinos and elephants, giraffes, and she had a great time. But there she is 1 week later saying she couldn't remember a single thing. In any conflict between the favoured parent and the target parent, the children automatically take the side of the favoured parent. Well, I think that goes without saying. Parroting adult language. After the mother absconded with the children to an unknown location, I eventually got the mother to answer my call on her cell phone. When I asked to speak to my daughter took the phone and said in a chillingly cold voice, "Hello, Bill." So there were numerous other examples where my daughter would use adult expressions, but if challenged would, of course, furiously assert that it was not using someone else's language. There was a declaration of independence. This was fueled by the mother, who asserted that my daughter at the age of 9 or 10 was really very mature and should be allowed to make her own decision on major matters such as how much time she spent with me. Interestingly, this maturity did not extend to decisions on, say, where she went to school or whether she went to the dentist. There was hatred by association. My daughter would denigrate my mother and family, even though she hardly ever saw them. It even extended to pets. At one stage, when I was seeing my daughter every couple of weeks and we had to drive 180 miles to do so, she said she really, really wanted a pet. And so at her urging, we bought her a pet guinea pig. So this meant that the pet mainly lived with us and would have to make the 360-mile round trip every second weekend. But after the first weekend, when she played with it constantly, on every subsequent time, she refused to go anywhere near it, saying that her mother had bought her one. So you wonder, how does this situation arise? And I think we've heard some of these this morning. There was the bad mouthing. I'm absolutely convinced, although you're getting things second and third hands, but I'm absolutely convinced that not too much good was said about me, and that's been subsequently confirmed by, strangely enough, I get on quite well with husband number 3. So I think he's seen me as a fellow sufferer. So he's. But why come to me of all people to complain about the wife? But anyway, he's confirmed a lot of my worst fears. There was the relocation that I mentioned. There was the calling me by my first name. She would call the new husband Dad. She changed the children's names. That was certainly a kick in the guts when I eventually found out at the school that they'd been enrolled in the new boyfriend's surname. There are even allegations that the mother and I had never really been married, which was that was interesting. But we were married in a registry office. So, and the next husband, though, she was married in a church. So she told the children that was the real marriage. The previous one to me hadn't really been a marriage. She'd often organise my time with the children. So there'd be a party that the child had to go to, and things that had to be done when she was with me, without any prior discussion with me, I might add. There were never clothes and toys were never ready when we turned up, and anything that we provided when she was with us were never returned. The children were interrogated. The children were allowed to make contact arrangements. Court orders were disregarded. There was what we call the teapot syndrome, which is when you arrive to collect the child, there's the body language of the parents' disapproval, and I think you can imagine that sort of look. There was, I think we heard a bit earlier too, the elder child, my son, was engaged to get involved so that the alienating parent didn't have to do much really after getting it started. One side was always identified as family, naturally her side. History was revised. There was projection. We always seemed to know what was going on in one way because I'd be accused of it, so we'd automatically put two and two together and come up with, oh, well, that must be what she's planning to do. Now, against that, I took the view that I didn't want to go to my grave thinking there was something more I could have done but failed to do for my children. Also, I'm often asked by people that don't understand these things, you're a lawyer, how could this happen to you? And I think we've already heard a few minutes ago from Mr. Klein that he's a lawyer and it didn't work for him either. But I was in the family court and related courts from 2001 to 2008, and the most I ever achieved was an interim order for 5 days a fortnight, but that only lasted for about 6 months. Even when I relocated to be closer to my daughter, I was still only seeing her every second weekend, half school holidays. In 2006, after years of the mother flouting the court's orders, I finally took her to court, and she was found guilty on 4 counts out of the more than 30 that I could have nominated just in that 1 year. But this didn't change anything. In fact, the mother wasn't in court to hear the judgment, and she continued to breach the orders. In fact, only 3 days later, I turned up to see my daughter, and she wouldn't let her out of the house. So finally, in 2008, when my daughter was approaching 12 years of age, I knew the court process couldn't go any further. The court has this peculiar view that by the time a child reaches 12, that child is perfectly capable of making decisions regarding the time to be spent with her parents. So it was time to give up, and I entered consent orders with the mother. Gave me some time with my daughter, but I knew they'd be breached anyway. So the only thing to do was to tell my daughter what the court's view was. I asked her only that if she told me she wanted to spend some time with me, then it had to be genuine, and I didn't want her running off. But unfortunately, on the first and only time she wanted to see me, over a week of the school holidays, she ran off after the weekend. So the current situation, I haven't seen my son for 11 years. He's just turned 22. He doesn't know that I access Facebook, but that is how I know that he lives in a city about 100 miles north of Sydney. When he left his mother's home after finishing high school, he left instructions that I was not to be told where he was, and so I've no way of contacting him. My daughter is now 16, and I haven't seen her for nearly 5 years. In the last year, I have had some limited email communication with her on a few occasions, but I could readily come up with a reason as to why she wrote to me that would deny me any comfort. She lives with her mother about 7 hours' drive from Sydney. I've travelled to the school on at least 2 occasions, but on both occasions she left instructions with the principal that she wouldn't see me. So, what to do? I think too many alienated parents go back into their caves after accepting their situation. Some few parents remain active in a wider cause, and obviously here is a good example. In my own case, this took the form of doing a weekly community radio show in Sydney called Dads on the Air. For 3 years in my hour and a half each week, I conducted interviews with people around the world on the topics related to men, boys and fatherhood issues and related topics. I invite you to go to our website, which is www.dadsontheair.com.au, and all the shows are on the website. You can, if you see an author, in fact, we've even interviewed Brian Ludmer, who's here. He is. Brian was a guest on our show, which was great. Catherine and I attended the Canadian Symposium on Parental Alienation Syndrome in New York in 2010, and that's where I met Brian, and this was in turn followed by radio interviews with many of the people involved on the topic, such as Dr. Bill Burnett, who's written a major text on parental alienation, which some of you might be familiar with. Now I commend ISNAF for putting on this conference, getting together experts in the field, keeping the movement going. We know the hurt is going on. We have to keep working for our children's sakes, as well as our own sake, to produce a result in what I consider to be the greatest threat to our society. And I think you can pick that up also from what Catherine said earlier with the effect on criminal law. What are we fighting for? I want to give an example from Australia which demonstrates what can be achieved when there is an enlightened approach from psychologists backed by a judiciary that lives in the real world. Gary Parmenter has given me permission to describe his journey. Gary lives in Brisbane and is the father of Sean, who was born in 1992. At that time, Gary was working as a wharfie and was active in the surf life-saving movement as a former champion. Until Sean was 4 years of age, there was a good relationship, but by the time he'd turned 6, he'd been alienated from his father, and there were many allegations by the mother, including physical abuse against the child. There was also an older brother and sister from a different father, and those children had also been alienated. The mother used the legal process to make allegations to the Department of Child Safety. She applied for domestic violence orders and did all she could to thwart a good relationship developing. There were none of these allegations was substantiated, and costs were awarded against the mother on each occasion. But there are no real penalties for a parent who makes up scurrilous allegations. I think there was a question over here before, and takes up the courts and everyone else's time in dealing with them. But in this case, the family court, Mr. Justice Lindenmayer, made orders when Sean was 9 that he was to live with his father. It didn't quite happen immediately. There was an appeal, but finally when Sean was 10, he came to live with Gary. It wasn't easy. The son, Sean, refused to acknowledge Gary as his father or call him dad. He was extremely rude to Gary and his parents, and during the first 6 months he ran away from home 10 times. Over this period, his only contact with his mother was 1 half-hour telephone conversation per week, which was very disruptive, but it was part of the order, so Gary had to go along with it. When Sean was 11, Gary changed Sean's school. The relationship began to improve. When Sean's mother married, Gary allowed Sean to attend, as well as some other face-to-face contact, even though it was often exploited by the mother. The situation gradually improved, and by the time Sean was 13, contact with his mother had been restored to every second weekend and half-school holidays. It took Sean 2.5 years to refer to his father as Dad. But now, Sean has grown into what his father describes as a delightful and well-adjusted young man. He's 20 years old, 6 feet tall, very active at sports, and he attends university and sings professionally. He lives with his father and regularly engages with his extended family on his father's side, and he has regular contact with his mother and siblings. Sean's mother continued to ask him to return to living with her for a long time after the orders were made, but Sean has not expressed any desire to do so for the last few years. So this is what happened when the parental alienation was recognised and the child removed from danger. I see this as the hope for the future. Thank you very much. If anyone's got any questions, I'd be very happy. And I just wanted to have one positive note too. In this country, I see that President Obama has addressed the Hyde Park Academy, and he has spoken about the importance of parents in a family. He said he wished he'd had a father who was around and involved, and generally very supportive. So I think it's great to be applauding President Obama, because I think initially he said a few things that were not very complimentary. So let's hope this is a turning point in the US and the rest of the world. Is anyone? Yes.
Do you have a comparison between Australia and Canada on family law?
Well, we've got Brian up there in the back. Look, Canada is where the White Ribbon campaign started, and I think that's a bad thing. I mean, not that domestic violence against women is a bad thing. In fact, what I'd go further and say, any violence, any domestic violence is a bad thing. But when you focus on one group and say that the problem is all because of men, and deny that men are in fact much more prone to domestic violence than women, and because they're getting attacked by other men as well as women. So I think that's a bad thing. But generally speaking, my impression is, from some limited contact with the Canadians, is that they've got the same problems as we have in Australia and you have in the US. So it's a worldwide phenomenon. So.
Are there any countries that you're aware of who do deal with it in a more effective manner?
Yes, I think as Catherine mentioned at the start, on my radio show I interviewed a Brazilian judge, Justice Perez. It was difficult because he didn't speak English, but nevertheless, Brazil, at his instigation, Brazil has made it parental alienation a crime. So they set out a number of factors. Yeah, look, it's great. It's the only country in the world that I'm aware of where they've done this, although I think there's a movement starting in Spain, and if this could spread from Brazil to Spain to the rest of the world, it would be fabulous, because it is actually illegal in Brazil. Yeah.
Given your past, and given what you've been through as a father, if you had a chance at do-over for yourself, 12 years ago, 11 years ago, 9 years ago, however long ago it was, what 2 or 3 things would you have done differently, or could you have done differently to prevent where you are now?
Well, I'd like, that's one thought, to be able to prevent it. I think I'm getting to the stage where I don't think anything I could have done would have prevented it. But there are things I would have done differently. And I think the most important thing is taking a lesson out of Dr. Richard Warshak's book, Divorce Poison, which I think some of us here regard as a Bible, is that you have to be active. I think if you sit back, and friends will often tell you, oh look, the child will wake up to himself or herself in a year or two. It's not going to happen. And in those difficult cases, I think you really have to be very very proactive. You have to, you don't criticise the other parent, but you don't necessarily agree with what's being said. If you hear an untruth, I think you have every right to correct that with your child. And those sorts of things, and you know, I won't go through them now, but if you read Dr. Warshak's book about the active steps you can take, I mean, the trouble is, when I was thrown into the situation, as I'm sure most of us are in this, are like this, that you know, there's no training. You know, you don't even know what parental alienation is when you first get hit with it, and all of a sudden, you know, the other side seems to be pre-programmed. They seem to be wired to do exactly what is required to alienate the child, but you don't know, and you're just trying to follow along on your best instincts and doing the right thing, which isn't always the best thing. Okay, thank you very much.
Hello, everyone. It's been a great, dynamic morning. I'd like to start out by acknowledging our speakers from this morning. Thank you all for an expert. I'm Cindy Hirsch, and I'm the current co-president of ISNAF. I'm an alienated parent. I have 2 boys, one 21 and one 16. I haven't seen the 21-year-old in 8 years, and I haven't seen the 16-year-old in 2 years. They're both pictured in your program. I made a dedication to them as Jake and Daniel, and I took this position at ISNAF to contribute, be supported by, and it's probably one of the greatest networks that I've had. While I don't have my children in my life, I have my community, my friends, and the people who understand me, get me, and advise me. So I urge everybody to take whatever role you can, participate at whatever level, whether you're an expert or you're a parent. There's a place for you, and you'll find a place of belonging here.